These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
Okay, so the next letter in your pamphlet should be stating interested parties. So this is written to Richard, who was a vice president at HSBC, and a third-party intervener, something of somebody, whatever, in Oregon. It looks like this. No, it should be after the 3-page and then after the 12-page. After this. Okay, then go 12 pages. There you go. Okay. Yeah, there you go. Everybody got it?
Is this step 2?
No, this is an intermediate step that I want to explain to you of what I've done, why I've done it, what you might be able to do with it for yourselves. Okay? So this says notice to principal is notice to agent, notice to agent is notice to the principal. I did that because I'm talking to two different entities. And I want both of them to know that if in fact Man Bracken is a agent for HSBC, I want them to know that. I want them to know that they're responding for them. Okay? You also do that in the response of when you send a letter to, say, the bank president, and you send the letter there, and then someone replies to you from the Customer Relations Department. Okay? Customer Relations Department is some $12 an hour employee down here, doesn't know anything about whatever we're doing, but they send you a letter, and then you reply to her. So you would want her to be aware that whatever she replies to is she's responsible for telling her principal that in fact that's what's going on. Okay? So this says, in regards to the enclosed notice of default and dishonor, please note that your corporate office, HSBC North America Holdings, is currently in dishonor of my notary presentment regarding HSBC Bank. Then it has Mr. W. Now responding as Allison somebody, whatever her name was, at Man Bracken, is a third-party interloper and as such has no first-hand knowledge of any event regarding the HSBC credit card. Man Bracken is in default of the similar notary presentment as of September whatever. You should verify your records as this matter should be closed. Yet I have noted in your letter, dated November 13th, that your intention is to proceed, which is a frivolous response and such will be deemed as harassment. As such, I will apply the protection from harassment in my presentation of July 27th. So my July 27th letter had a little notice about harassment. To Man Bracken, letter dated November 13th. As such, you will now owe me $1,000 payable within 30 days. I await your payment. Okay? So I put them on notice that if they were to harass me because of sending me documentation and information that had nothing to do with or that had something to do with my account that was either closed or they had not responded appropriately, that I was going to charge them. Now, I could follow up with this if I chose to. I could collect the $10,000. I, quite frankly, just want them to leave me alone. You'll have to decide what you do with that. But I wanted to show you this as an opportunity of what one might say when someone's bothering you and they don't quite get the full picture that someone at the top has already agreed that this is a closed account and someone down here is still sending you information. Okay? Does that make sense? Absolutely. Because you have a letter dated from them that says, you know, they're requesting this information. You have a copy of a letter. I mean, there would be a letter attached to this that showed them that they had actually sent that letter. The question is about harassment. Oh.
I said if I'm hard-nosed, which I tend to be sometimes, and I send this notice out that they're going to owe me 10 grand and they don't pay it, I can sue them in court for it.
Yeah.
And
or if you didn't want to go through court, you could go through an administrative process, get your judgment, file your judgment, and put a lien on them. Right. Administratively versus court. Your choice. One's with an attorney that's not on your side, that's not working on your behalf.
I like it.
Okay? You were married to an attorney, right? Are they ever working on your behalf?
Excuse me?
Are the attorneys ever working on your behalf?
Excuse me?
Okay. Okay. I rest my case then, I guess. Okay. So the next letter in the packet has to do with a statement of account. Okay? Brandon really likes this letter because he wants to know, he wants them to agree that the statement of the account is zero. Okay? You can send this with either your first presentment or your second portion of your presentment, which is your notice of fault and dishonor and opportunity to cure. But if you send it, it's an opportunity for them to agree to it. Because an unrebutted claim stands as fact. I'll repeat that. An unrebutted claim stands as fact. So if in fact you send this out with your process and they do nothing with it, they've now agreed that your statement balance is zero.
Plus, that particular letter, the way that it's written, is in reference to Article 9 of the UCC, Section 9-210,
Correct.
Which is a request regarding a statement of account. And the nature of that particular part of the commercial code states that if the debtor or representative thereof presents to the alleged creditor a request regarding a statement of account stating a balance, and the creditor does not respond under penalty of perjury, whatever the debtor asserts the balance to be, it is so. So they have 14 days to respond to it, and if they don't respond in 14 days under penalty of perjury, that is the balance on the account.
So Brandon would like to say, this is your opportunity to take what I put down here as zero and put in whatever amount you would like. Because then you're agreeing, they're agreeing if they don't reply to you that that's your statement of account.
Ooh, we should try it with a bank, like my checking account.
Right.
My balance is $10 million.
Why would, okay, so he just asked a question, put in a negative number.
They owe you money. The balance is due, that would mean they owe you money?
If
The negative number?
But this is a statement of account. This is what your account balance should be.
To achieve what you're trying to achieve, I would do it in a kind of a backwards kind of way where I would establish an account. The account number would be my certified mail number of my first presentment of demand for payment, and then I would follow up with that letter right there showing that the balance on the account, they would be listed as the debtor on it though.
On this letter.
And actually, you'd have to execute, wait, would they be the debtor? Yeah, see, you wouldn't have to do that method right there. You would just send them a statement of account, a verified statement of account. It wouldn't be a request regarding a statement of account. The debtor makes a request. If they owe you money, you're the creditor, they're the debtor, and you're just sending them a regular verified statement of account saying, here's the statement of account. You owe $10,000. And if you don't respond in 14 days, you agree you owe $10,000. Only sufficient responses are affidavits and whatnot. So you put them back on the defensive for having to prove that they don't owe it. Remember, this is how they get you to agree that you owed the money on the debt. Because they do the same thing to you. They send you that debt validation letter, and when you don't respond, that's the proof that you owe the money. They don't have any proof other than that. They get you to testify by not responding that you owe the debt. Now, if you wanted to do the same thing, you just merely flip that process around. The funny thing is, you guys want to learn how to be effective in commerce, look how it's being done to you, and just flip the process around.
Yep.
IRS is the best at it. IRS has administrative process down. They do it better than anyone. And read their letters. They're structured very well for administrative process. And it wouldn't be a bad idea to become familiar with the verbiage and the construction of their letters for your own benefit. You know, I love like a lot of the demands that IRS sends you. They'll have like, you know, subheadings on each paragraph, or they'll have a subheading and maybe 2 paragraphs and another subheading. It'll be why you're getting this notice, boom. What you got to do, boom. If you don't do it, boom. Yeah.
Yeah.
And,
but they lay it out.
But they lay it out.
Quite clear.
Yeah, quite clearly. This is what's going to happen if you don't respond. Here's the way you can respond. Like they're doing exactly what she's explaining that we do.
Right.
That's how we learned it. Let's look at how the pros do it.
Look at how the pros do it. So anyway, also I want to point out that on the bottom I have signed this as the authorized representative. Okay? So making clear that you know who you are when you file documents. Okay? Yes. Yes.
Would you also include, as you have in some other documents, all rights reserved under UCC 1207 or 1308? Would you necessarily do that, or just placed authorized representative?
I wouldn't do the UCC.
Not
That particular UCC language is, be knowledgeable of when you would want to use that language, because a lot of times that language would actually nullify what you're doing. Yeah, you want to be knowledgeable of why you would put that. Do you have those sections memorized? Do you know what those sections say?
1207 I'm pretty familiar with, yes.
Okay, what is it?
1207 states that you're not obliged to perform under any contract that you've not voluntarily or knowingly entered into.
Yes, and now you've just, basically you're entering a contract knowingly. So why would you use that language? You see what I'm saying?
That's a knowledgeable point.
Yeah, like I said, it's just about knowing what you would use those for and when they're, because you could be nullifying your own document by putting that on there.
No need.
Yeah.
Yeah. That's why we always say, know your process, know why you're doing it, totally understand it, and totally understand all the rules of the game. Because if you don't know the rules of the game, you're going to get kicked out. It won't be pretty.
Critical knowledge is a dangerous thing.
But, totally. Okay? Yes?
Getting back to the terms that are in here, there's one little phrase in here. It talks about the amount of unpaid obligations secured by collateral And if you put a phrase like that, are you then talking about a secured debt?
You
or-
could be.
Okay, so we would want to make sure we tailor it to our specific type of,
Correct. Make
The,
sure
the
you.
thing is that section, Article 9, Section 9-210 is the request regarding a statement of account is specifically geared towards collateralized debt. And that's what I actually mentioned that to her right before we got started, because I noticed she had included it in there. I go, you're supposed to list a collateral here. And what I would list, if I was going to use this particular statement with a credit card, which is typically an unsecured debt, I would list as the collateral my public trust, which would be the name in all uppercase letters with the social security number after it with the dashes. That's the collateral, that public trust, because that's where the funds, why they were able to access the funds is because of that public trust. So the public trust is truly the collateral.
Okay. So, turn the page, and we should be on a notary's certificate of service. And an additional 3 pages called Notice of Fault in Dishonor, Private Opportunity to Cure. Now, Brandon has about, I think, 6 different types of notice of default and dishonor on the website, okay? There's all kinds for all different kinds of things. Read them carefully, understand them, and use the one that you like the best, that feels good to you when you read it, so that you know and understand what you're doing. So, you've gone to bank, you've sent them the first set of the process. You said, hey, Mr. Banker, this document over here says that I owe you some money. I've sent you a letter out. I've said, hey, show me where I owe the money, and we'll be happy to continue on. They didn't respond, okay? I gave them originally a 10-day window, didn't I? So in 10 days, I'm going to get my notary to send out my next letter, which is the Notice of Fault and Dishonor and Opportunity to Cure. I'm saying, hi, Mr. Banker, how are you? I didn't hear anything from you. What you up to? Here's my record. Here's where I sent you this letter. Here's what I said in this letter. Here's the information that I told you about, okay? So this letter says that I sent him 3 documents back in November, okay? Tells him what a dishonor is, what my interpretation of a dishonor is. Tells him what my interpretation of fault is. I don't want to leave anything ambiguous. I want him to know that I understand my process, and that what a default is, and what a dishonor is, and what default or fault is. And I also tell him what a response is, okay? And that's a couple pages long. And I talk about damages and the default, okay? And they send it out to him, okay? So this is my, hi, how are you? 10-day later, didn't hear from you. Are you alive? Are you awake? Do you know what's going on? Are you going to respond to me? Okay? Tailor this to work for you. Don't copy this just because I did mine this way. I may have put a big boo-boo in there. Okay? And you wouldn't want to do that. Okay? I wouldn't really want to do it either, but I'm just saying. Okay? So then, you come along with the next process. Next page. Oh, actually, the next page says it's a notice of fault and dishonor. I did this letter in regards to a third-party debt collector. Okay? So I had them, I did one specifically for them, just a nice little 1-page letter that basically says, you know, you're a third-party debt collector, you haven't any legal standing, you don't have any first-hand of the knowledge, I didn't enter any contract with you, you know, I just want you to go away. Okay, bottom line. And if you pursue me, I'll charge you $10,000 per event. Okay? So, that's what this is. Okay, so again, make this your own. Understand the words in here and do it only because you know what you're doing, okay? So then 10 days later, 20 days later, well, actually, that's what I was using, wasn't it? Okay. Yep.
On the notice of fault in dishonor to the, on the notice of fault in dishonor to the, okay. Yeah, it's on. Okay, on the notice of fault in dishonor to the third party.
Great.
I noticed that you don't have that notarized.
Okay, I would have a notary certificate on the front.
Okay,
I just didn't include it.
okay.
And what I noticed in my packet was, this is what I was using as step number 3. Some of my paperwork is still at home. This is what I had available on my laptop, because I haven't been home.
Are we going to make an effort to change that for the download?
Yes, we will make an effort to
Make it complete?
make it a complete process, yes. Okay? So this would be similar. This is just for a third party, but this would be the similar same thing, only, hi, Mr. Banker, I didn't hear from you. You're now in default. You're now not, you haven't responded to anything I have. You're under the Uniform Commercial Code, the UCCs. You haven't followed along with my process.
And right now, PJ's passing out some index cards, and if you want us to email you the document packet when it is finished and complete, please put your name and email address on there. And Nancy will email you a zip file with all the documents when we have the process complete and correct.
As a matter of fact, the next letter, they got out of order, but the next letter is your notary certificate of service. So that's what goes with your notice of dishonor. Okay? So those two documents go together, so it's only 2 pages for that particular item for the notice of fault in dishonor. Okay? But here you're just saying, I did this on this date, I did that on that date, I didn't hear from you at all. What's up? So we're now claiming that you have no standing and no interest in what business I'm doing here, so I'm going to have my notary now fill out their form and do what we call a certification of non-response and non-performance. Okay? This particular one is for a different party, but the process is the same. So you will have your notary, you will prepare this document for your notary. The notary will then certify that this is exactly what they did on those days that they did it. So I started my process, my first process on this date. I had signed the documents on this date. Then the notary took them and mailed them out on this date. Then they were arrived at the bank on this date, okay? And it was through this mail, either registered number or certified number. That completes that first one, that first step that you did. Then you'd send them out a notice of fault and dishonor and opportunity to cure. Okay, so you signed that on a particular date. Then you also had the notary take it to the post office on a particular date, and it arrived to the bank on a particular date. Those 3 things are part of your second process. Okay? The last one is the third process, which is the notice of default, or in there I call it a notice of fault and dishonor. Okay? In this step, the same thing. You signed the documents on a particular date, had the notary take them to the post office on a particular date, and in the end, they arrived at the bank at a particular date. All of these dates collectively, all of them together, with all of the names and headings of all of your paperwork included in this, is your judgment. Okay? Now it's done 2 ways. There's a certification at the top, and then the second page there's a certification of due presentment of notice under notary seal. So it's presented in 2 formats. One's more detailed, one's a little less detailed, okay? But they go together.
Wait till you see my abstract of administrative judgment.
Ooh, yeah. Okay.
I'll release it
Yes.
in the
Yes.
next month or 2.
There is a reason that you do both of them, okay? The first one's certifying the non-response. So this is, hi, I'm the notary. I did not get a response back that was per the agreed way to respond back to me. So I'm going to certify that I didn't get any response back from these banks or from this particular bank. Okay? That's what she's certifying on this one piece of paper. I sent it out here. This is what I sent in the packet. I did not, they received it, you know, we signed it, we sent it out, the bank received it here. I didn't receive anything. Okay? So then we started on our next process. This is your judgment. Okay? The next one is the certification of due presentment of notice under notary seal. This is where she says, in my particular case, my notary is a nice lady, and so I say that on this date, July 27th, I noticed and presented under seal a fiduciary relationship contract, affidavit of individual surety, release of personal property from escrow, and accepted for value coupon. And the notary certification, which says, the above noted parties were presented notice under notary seal that the certification of non-response or default within 10 days of postmark would compromise their acceptance for the facts set forth. Huh? Comprise? Oh. Well, that's what happens when you read with glasses and not, okay? Here's the deal. I should read like this, but you know, it's just the way it is. Set forth within these instruments, the time having elapsed for their response thereof. So each one of those items is outlined, okay? So she said, hi, I gave you this, and here's my record. This is a complete record. I sent it out, didn't get a response. Sent it out, didn't get a response. Sent it out, didn't get a response. Okay? And from there, then you work on getting your judgment into action to work for you. And there are several ways to do that. Brandon, you want to talk about that, or you want to talk about the judgment and getting it enforced and in effect?
Do you want to complete your process first?
I have completed my process to the judgment.
No. Don't you have to do something on the credit reporting agency?
Oh, thank you. That's the big deal, huh?
Say, yeah, I could.
Okay.
My next seminar is on enforcement. You want to hear enforcement, come to my next seminar.
Okay, there you go. So after you've done this process, and you've gotten all of these people to agree, so you've gotten Bank A, you've gotten third-party credit person B and third-party credit person C to all agree that this stuff is fake, fraud, and whatever you want to call it, doesn't exist, okay? So now that you have your judgment, I love this website. ftc.gov. On that website, I have my favorite little ugly brown box up in the right corner. Okay? You click on the ugly brown box, and then you click again on the ugly brown box. And you click one more time on the ugly brown box. I don't know, 3 must be the magic number for getting into this particular website. But it talks about filing a complaint. Okay? This is how I'm going to get them to agree that what they have done is not my responsibility and I want my credit report cleaned up. Okay? So I'm not going to tell you exactly how to fill out the form. What I will tell you is my understanding is that it is identity theft. And that is the way that I proceed in filling out that form. But you better know why it's identity theft.
Why don't you explain your understanding and articulate the whys of your choice of filling it that way.
Okay. So my understanding of identity theft is someone takes your information and uses it without your knowledge. Okay? So, does not the bank have you sign on the dotted line for money they say that they're going to lend you? True or false? True. Okay. Does not the bank then issue you a credit card? And from what my understanding of it is that our payments go to the servicing agreement and the money flows back into the account through my account. That's my understanding. Now, did I give them permission every month to go to my private account and get my own money? I signed a document, but did I know that they were going to be reusing my own money every month? No. So that's what I stand on. That's my understanding of it. Now, you may not come to that same understanding of it. You may have a whole different reason. And there's many other reasons to take advantage of that website and utilize it to get your judgment entered and processed through there so that then they will take it off of your credit report.
I would say there's another angle of looking at that is that your process was to validate the debt, right? Mm-hmm. They failed to validate the debt.
Yep.
So clearly there is a misidentification there mm-hmm. because it's not a valid debt.
Right.
So.
Access their money when they give you a credit card?
Is it their money?
Well,
In this requesting of a statement of account, I'm asking them, is it their money? When you do the debt disclosure statement, I'm asking, did you give me any money?
no,
That's
they
what
didn't
I'm
give you
asking.
your money because you applied for a credit card from the bank.
Bank is serving as an intermediary to your credit. See, you can't access your credit directly. The banks are intermediaries to accessing your credit. They did that intentionally because if we just let the American people access their credit unlimited, the economy would have collapsed a long time ago because everyone would be getting out ridiculous amounts of money and then the dollar would be worth nothing and we'd have to carry around billions of dollars to go buy groceries. Yeah. But the fact is, they put a control mechanism in place, and the banks are the intermediaries, and the banks gauge whether or not to give you access to your credit based on how much money they can make off of you.
And your ability to pay it back.
Your credit score, right.
So they keep wanting your credit score to be good so that because when you keep paying them back, that means you'll borrow more money, which means they make more money, which means they just keep going and going and going and going and going.
But if you perpetuate the cycle of this is how it's done, and if we do it this way, then everyone's going to believe the same philosophy.
Right.
And I have you now under my thumb, and I control every aspect of your
So
life.
is that why our economy is collapsing?
Several, it's
But that's one- but that's
it's
one-
not a one-stop shop fits all.
Well, yeah, I
on
know, but
that.
that's definitely one of them. But it's
Yeah.
not just here. I mean, it's all over the world. I mean, all over
Right.
Europe. I mean, there's big trouble everywhere.
Correct.
So the system is flawed.
On purpose.
I wouldn't say it's flawed. I would say it's being abused and misused because the intent behind the nature of the system is good intent. What the banks are doing is they're floating these securities, like they're literally taking securities and photocopying them, like promissory notes, and putting them into multiple securities. Yeah. So they're trying to make money out of things they shouldn't be making money out of. They're breaking the ethics of the system, and by doing that, they're jeopardizing the stability of the system and the high rate of default. See, the thing is, investors buy these securities based on the future value. And if everyone stops paying their mortgage and everyone stops paying their credit card bills, there's no value in those securities anymore, so the investors don't want them, they dump them, and then the bank's bond rating goes down, so no investors want to touch that bank's securities. So it's a domino effect. There are so many things being done unethically that it's just all crumbling now because everything's caught up with it.
Right. Okay.
Okay.
Yes.
I could ask a quick question. Donna, quick question on this, the certification of due presentment. When you talk about the presentments, the release of personal property from escrow, accepted for value coupon, that's saying that that was the start of the process, not really the debt verification.
Right. That was not, that process, I did not have a debt verification.
She gave you an
Okay.
example that has nothing to do with this process. Are you going to actually give them examples that are actually synced up with this process?
Okay, here's a little secret. You ready? I haven't ever had to do one. I haven't ever had to do a certification for a credit card. They've all gone away before that. I haven't ever had to do one.
But you're not answering the question.
Huh? Well, I do. I'll make one up.
Okay, thank you.
Will I make one up? Yeah. Okay. Yeah. If I get home. Okay, great. So any other questions? Okay.
If you are engaging in this interaction with your bank and they're going to challenge you in written response, have you ever been challenged over the phone where they try to recontract over the phone? And let's say, for example, that your spouse wasn't on the same page with you. Would they possibly jeopardize your process if they recontracted?
Could. Yeah. It's always best to be on the same page. Right. They go through a rigorous process of who they're talking to. So, hi, are you Mrs. Jones? Yes, Mrs. Jones, great. Okay, do you have an account together with your husband? Yes, okay, great. Okay, the next, and then, and do you know about this credit card? Do you have any idea about this particular thing that they're doing? Do you have any knowledge of it? Okay, great. They keep moving you along in the steps to find out how much you know, so that if you don't know anything. Okay, well, if you actually answer the phone, I have a few suggestions that I've used that some are kind of fun and some are kind of like, So one I like to use is, I'd really like to continue this call, but I need to know who you are. So I need your name, I need your address, I need your phone number, I need your social security number, I need all the information that you have about me so that if I have a problem with some information that you have given me, okay, or you haven't represented what I've said appropriately, I have some way to collect damages on you. Okay? Yep, you're right. They'll call you again tomorrow at dinner time.
I'm just saying then you call them tomorrow at dinner.
Oh, I call them at dinner time. Okay. So then there's another one I like to say, which is, I don't do business over the phone. I only do business in writing. I'm sure you would understand that over the phone, things could get miscommunicated. Okay? They just can. And then my other one that I really like, that not a lot of people like, but I think it's kind of fun, is, gee, to talk to me over the phone is $10,000 an hour. Would you like to continue talking right now? Well, you can't do that. I'm sorry, I'm of legal age and of ability to contract. Would you like to continue talking? No, you can't do that. This is your final opportunity to agree to $10,000 per hour. Would you like to continue talking? Okay. My point is, whatever you do, however you work it out with your wife, okay, she's not on board, but she better get on board, because she's going to recontract with someone that you don't want her to. And if you like her, you better figure it out, because otherwise you're going to end up in divorce. Huh? Yeah, you're going to choose something else, and it's not going to be pretty. Okay? Yeah. So, another question?
A variation of that handling of that last call is I actually only handle this by written presentment, in writing, but over the phone, my rate is $500 a minute. We're at 2 minutes already. Are you still on board for the balance of the call?
Right, yeah.
Usually they wilt pretty quick.
Well, but it's all contract. And when they say they can't do it, you can say, I'm of legal age and I can contract at any point in time. Yeah, whatever it is. For quality control purposes only. We must control the quality of the call, so I must record it.
Full control of this call.
Full control. I got to have everything. I'm in the driver's seat. I got to.
Just a minute, let me get my report.
Yeah. Right. Okay. So, any other questions? Yep. Hold on.
Have you actually had to take this to the FTC and file, those
I do
little-
every time.
You do every time, okay.
I don't want it on my credit report.
No, not at all. And this makes it go away?
Actually, if you look on the Google group, I recently, when was it, a couple months ago? I told someone I gotten a letter from HSBC, as a matter of fact. A nice little letter from the Office of the President, liaison office, whatever. Okay, well, anyway, and I posted it on the website, on the Google group. So you can go Google my name and up credit card, and up will pop this letter. And it comes from them on their letterhead, and it states that we're really sorry for the inconvenience, and we'll be happy to, report to the 3 credit bureaus, and, it will take a certain amount of time for it to get taken care of, and it has.
What about these guys that were these niggas that go on the phone and try and, as you mentioned before, try and negotiate your loan to a lower rate, and they give you a week to decide?
Why would I want to recontract with someone?
Well, that's what I thought.
Okay. And it goes back to, do you want to do business over the phone?
Yeah, I was told, forget it, don't even pay it. What are they going to do? That's why
Okay.
Don't worry about it.
Can you answer the question now, continuing in the future, getting new cards?
Okay. So once your credit report is cleaned up and you handle all this stuff, then it's about rebuilding your credit. So if your credit is really in the tank and you've really messed it up and whatever, the best thing to do is to go out and get a secured credit card for $500. Most companies, there's 2 or 3 that will allow you to do it. You put a $500 in a CD, put it in there for 6 months, you rotate the balance and keep moving the credit through there so that they get their return of money, because that's all they're interested in is the money, okay? Also beware that people sometimes, actually my sister recently, had 2 credit cards be canceled because they paid their bill off every month.
Yeah, that's happened to me in Boston.
Okay? Credit card company was not making any money off of them.
That's right.
So fine, we're going to take it away and you just deal with what you want. Because we're not going to make any money on it. So they'll do things like raise your limit, or like decrease your limit and raise your interest rates. They've got a variety of things now to just try to make it miserable for some people to have a credit card. Secured credit cards are probably the best way to go. My understanding is that does not create debt or, global world issues kind of thing. But traveling makes that difficult because they don't always respond the same way. If you need more money than $500, then you'd have to have that put in advance, and you got to have a plan to how to make that work.
And I would suggest, if your intention is to operate as a creditor in commerce, that you stay away from creating debt, like credit cards. If you're going to create, if you want to have the convenience of having a card that you can use for your transactions, I suggest you use secured cards or debit cards and stay away from creating debt altogether, and start putting your money maybe into buying up debt and creating passive income through the purchasing of debt and then becoming a creditor to whoever you're buying the debt from. For instance, you could buy the debt of the United States, get a Treasury Direct account, and you could buy up notes and bonds of the Treasury, earn interest on them, and actually now at that point you're a creditor to the United States as opposed to a debtor to the United States. What I would say that really what you're looking at, if you're looking to do this process, look at it as an opportunity to shift your paradigm.
Yeah.
Live in a different space where you're not the debtor. Because if you keep creating debt, you're going to be hurting the public system. And we don't want to hurt the public system. And if as creditors, we want to operate outside of it, and when we do operate inside of it, all we're doing is benefiting it, and thereby creating a trust relationship with the public that puts us in the position of trustee and them in the position of beneficiary, and thereby creates a relationship of which the nature is, I have a paramount security interest in all that I hold, as opposed to I'm a debtor, I have no interest in all that I hold. So it's a new way of looking at commerce. What's that?
Yes. Very
Oh
healthy.
yes,
Very healthy.
I decided years ago. This is probably one of the things that got me going down this path. But I had to declare bankruptcy in 1995 or something like that, 96. And I decided at that point, I'm never going to be in debt again. I decided no more credit cards, no more loans, none of it. And my life has been a lot simpler since. You know, I only buy something when I can afford to buy it.
What about cars?
Yeah, I only buy cars cash.
When you can afford to buy it.
Yeah, when I can afford to buy it. Now, it sure does suck if a car breaks down and I ain't got the money for a new one, but I make it work. I use public transportation for 2 years and still ran a business using public transportation. And tell me that was a stretch and a half, just being an independent business person running an independent business and having to take the bus to see my clients. You know, it was definitely, I definitely had to get up a lot earlier and go to bed a lot later, because the public transportation system doesn't quite move you around as effectively as your own vehicle. But it was an opportunity for me to see what it's like to live life without debt. And right now, it's the way I prefer to operate. I like the fact that if all of a sudden I'm all out of money, I'm still not really in a difficult situation, because I don't have constant bills building up that I'm trying to pay back every month.
That reminds me of a statement that Donald Trump made when he was walking down the street one day with one of his friends, and there was a guy that was panhandling for money. And this was when Trump was in trouble. He owed everybody a lot of money. And the guy says, well, why don't you help the guy out? He goes, what do you mean help the guy out? He's better off than I am. What do you mean? He says, well, he's not in debt. I got $100 million in debt. He's much better off than I am.
Mm-hmm. Absolutely.
Yeah.
Yeah, Donald Trump is speaking some truth there. It's
Yes.
much better to be at zero on your ledger than $100 million in debt.
Then he learned how to leverage the debt. That's another subject.
Yeah, that is a totally different subject.
If there were any reason to want to keep an account open, for example, could you put on your statement of account a balance of, say, $5 or $10 or something like that? Would that keep the account open?
Would it keep the account open?
This
Not-
process will not keep
will
account
not
This
keep
open.
process will
any
not keep it
ca-
open.
Will not keep any account open.
Well, let's close it.
The bank would be insane to keep your account open.
It's kind of like the people, it's like I told you earlier about the people that are paying their credit cards off with A for Vs and sending them off in for 1040 Vs and that whatever. I have yet to see someone that their credit card lasts more than 6 months before it gets closed down, because the bank isn't doing, I mean, they're not making the money. So. Exactly. They want you to go away and not tell your friend. Exactly. Yeah. Yeah. Any other questions? No? Well, I thank you for joining us tonight. Appreciate your time and effort. And, huh?
We don't really have any time for it.
Okay.
I only got 20 more minutes in this room,
Okay,
and that's a
about time to
3-day conversation.
wrap it up, so, okay? Thank you very much, appreciate your time, thank you.